The EB-5 Immigrant Investor Program offers a pathway to a U.S. green card through capital investment. However, when an investment fails to meet the required job creation or capital maintenance targets, investors often face the daunting question, can I sue the regional center or project developer? Understanding the EB-5 investment structure. It is crucial to understand that EB-5 investments are typically structured as limited partnership interests or debt instruments within a new commercial enterprise. The investor is generally not an employee or a direct shareholder in the operating company. The role of the regional center. Regional centers act as intermediaries, sourcing projects and managing the flow of EB-5 capital. While they facilitate the investment, their liability is often limited by the offering documents. Legal avenues for investor recourse. When an investment goes awry, leading to denial of I-829 petition or failure to secure a return of capital, investors have several potential legal remedies, though success is heavily dependent on the specific offering documents. 1. Breach of contract claims. The primary recourse often lies in reviewing the private placement memorandum and subscription agreements. These documents form the contract between the investor and the NCE Regional Center. Failure to adhere to the promised investment timeline. Misrepresentation of material facts regarding the project's viability. Failure to manage the capital as stipulated. E2. Fraud and misrepresentation. If the offering materials contained deliberate falsehoods or omitted critical information designed to induce the investment, a claim for fraud may be viable. This is often the most difficult claim to prove, requiring evidence of intent. Proving fraudulent intent in complex securities offerings requires rigorous documentation and expert testimony regarding industry standards. 3. Securities litigation. Since EB-5 investments are generally considered securities, federal and state securities laws may apply. Potential claims include violation of the Securities Act of 1933, violation of the Securities Exchange Act of 1934. Note that many PPMs contain mandatory arbitration clauses, which may force disputes out of traditional court litigation and into private arbitration forums. Challenges in suing EB-5 parties. Litigating against regional centers or developers presents unique hurdles. Jurisdiction. Many regional centers are organized in different states than the investor resides. Waiver of rights. PPMs often contain extensive waivers limiting the liability of the general partner or manager. Financial insolvency. If the underlying project has failed, the defendant entity may have few assets left to satisfy a judgment, distinguishing between business failure and malfeasance. Courts often differentiate between a legitimate, albeit unsuccessful, business venture and actions constituting actionable negligence or fraud. If the project failed due to unforeseen market conditions, remedies are severely limited. Conclusion: due diligence is the best remedy. While legal remedies exist when an EB-5 investment goes wrong, they are often complex, expensive, and dependent on the specific contractual language signed. The most effective remedy remains exhaustive due diligence before investing, focusing not only on the job creation potential but also on the track record, corporate structure, and indemnification clauses protecting the investor. If litigation is contemplated, investors must immediately seek counsel experienced in both immigration investment law and complex securities litigation.